Laura, when you're ready, we can go on the record.
You're on the record.
Oh, we're on the record. Okay, perfect. Then let's call your case. Page 9 through 11, State of Nevada versus Meta Platforms, 886110. Counsel for the state, go ahead.
Good morning, Your Honor. In court, Michael Gayan on behalf of the state. Also with me is Matthew Bush, Richard High, and Chris Terzo. And we have so many people observing only on Zoom that I will just note that there are a lot of people on behalf of the state observing only on Zoom. I won't go
Okay,
through the whole
more than
list.
welcome to.
Yep.
Okay.
Thank you.
On behalf of defendants, please.
Good morning, Your Honor. Tammy, Peterson, bar number 5218, also present with me in court. This morning, Mr. David Sneed, who's admitted pro vice, behind me, Dan Waite and Dan Polsenberg from Wamble Bond. There are also a number of people who are simply observing on here. Your Honor, if we could inquire, because we didn't recognize two of the names, just want to clarify who they are. Jacob Telly, is he with the state, Mike?
Never heard of him.
Okay, we're not sure we know who that is. Daniel Agozi.
Okay, well,
Also never heard of him. He could be with the state, but I've never heard of him.
okay, well, let's find out because it's a public courtroom and remember, this is subject to a media request and so it can be recorded, which when we get to more your motion, we're going to need to discuss if there's any aspects that you need me to address, not really for your Rule 16. I can't imagine. But let's find out. Okay.
Scannon.
Great, thank you.
And what was the other name, please?
Mr. Daniel Agozi.
And they are put in with.
That's on me.
That's your firm.
Yes, that's my part.
You invite summer associates, don't you, to get this wonderful educational experience?
Lawyers in action, I think, is what they've described it as at our firm, so that's on me.
No worries, okay, okay, so we're all good, okay. And like I said, when we get to the motion, if there's any issues, you all are gonna need to raise it to this court's attention because of the fact that obviously it's a public courtroom but the media request is limited, but if it impacts anybody else who's just observing, you have to tell me, okay? So
Yes, Your Honor.
thank you so much. Okay, so Rule 16. Well, first I'm going to say, I'm more than glad to put you to trial in 6 months if you want it, because remember, this is a business court case and we are very efficient here in business court, right?
Yes,
So
Your Honor.
we're more than welcome, despite statements made to the contrary at legislative and others, I don't think anybody can say that this department has not offered people to go to trial quickly. So does anybody want to go to trial in 6 months or less?
Michael Gayan on behalf of the state. No, Your Honor, but I
about
would
Meta?
never dispute this
Okay.
court. This court is willing to accommodate the parties for a quick trial. The state's position on the schedule is laid out in the JCCR. Happy to go through that when we get to that point. But yes, we do appreciate the court's accommodations in all matters.
Counsel, do you know what I'm talking about?
No, Your Honor.
Okay, do you want to go to trial in 6 months?
No, Your Honor.
Okay, or less, okay. What I'm talking about is there's been some statements made and supposedly applies to all business court judges, and I'm a business court judge. I was surprised to hear said statements because I don't think anyone would say that this department has not offered to accommodate people at whatever time they want, sometimes within less than 24 hours and sometimes even less than that. So what I did not want to have is if there's any issue that somebody thinks that the deadlines you all are requesting are too long, please let me know right now. Because I want to ensure that you all get a timely trial, but I also want to ensure that you get trial time and dates that meets each case's needs. So if anyone's going to say you're not getting to trial quick enough, please let me know now and I'll be glad to make it 4 months, 6 months out, whatever you think you need for a quick trial. Anybody want that?
No, Your Honor, on behalf of Meta.
Okay. Sorry, it was, and state already said no. Okay, like I said, I have to ask that because there's not a single one of my business court cases that I am personally aware of where there hasn't been requests for continuance or anybody, I keep offering and nobody takes me up on quick trial dates, but then sometimes then I somehow heard that we're not giving quick trial dates. So if you want it, I'm more than glad to give it. Okay, so let's go. You have 2 sets of dates. I mean, you put in your JCCR 2 competing dates. Okay. So what I think the best way to do it is, while I'm appreciative, as lawyers, you're probably prepared to give me a brief explanation on why you think your dates may meet the needs of the case more than the other sides, or that maybe there's a plan B. And I will tell you, as far as the time for trial, whether it's 6 to 7 or 8 to 10 is really not as much of a concern for this court, because we'll make sure you get the time you need. Really, what we're trying to focus on is to get you the deadlines that you think you need that are reasonable in light of what you think this case needs. And with that, my other preamble before I actually let you all talk is, you probably saw, because you're probably looked at it within minutes of when you got it, the court did sign with some edits, some minor edits that weren't anyway large, but if anyone wants to discuss those edits, your appointment of a special master. Does anyone have any questions on that? Or
Michael Gayan for the state. No, Your Honor, we saw the court's order. I think that all makes sense, and we appreciate the court being thoughtful about that.
We're in the same boat. We saw the court's order and we don't have any issues with any of the edits. We're thankful the court has issued the order.
okay. So, and the reason why part I'm asking that is when we get to the motion, I'm going to have to ask you, the question is, for some reason, do you all think that that motion would still be properly before the court? Because I don't know if in the last 12 hours-ish, if you've already retained the special master and take a different position. So I can stay tuned on that. I don't necessarily need the answer right now, but I just was going to ask that question. I was giving a heads up. Or if you want to answer, go ahead.
Sure, Your Honor. Michael Gayan on behalf of the state. The parties did notify ARM and Betsy Gonzalez of the order, and there's been some correspondence about setting the first hearing within the 21 days. I think there was also a question about preferred day of the week to set hearings, and then also frequency of regularly scheduled special master hearings. So there were some questions from ARM's administrator to the parties. We were discussing on the state side. That's part of what we were chatting about off the record in between. So the parties are working together to kind of get set up with ARM and Special Master Gonzalez. But in terms of whether the motion for protective order is more appropriate to be argued here or in front of the special master, we have not discussed that. I have not discussed it with my client. Mr. Bush is here ready to argue it if everyone wants to argue it here today, but I think technically under the stipulation and order entered yesterday, it's probably more appropriate to be handled by the special master in the first instance, and I don't know that the state would necessarily object to that.
Court doesn't have a position. I just wanted to hear the party's position. I'm prepared and ready to rule on it, particularly since I did, well, the timing when you all provided me the proposed order, I turned it around very quickly. You know, it appeared that people wanted it all to be heard by this court because, but once again, if you all have a joint agreement differently, I will tell you, if either side says that this court should hear it, I'm going to hear it because you've not yet retained the services of a special master, and I'm not going to have delay time periods. And since nobody raised an objection, knowing that you all were submitting a special master, that it should be done differently, I was intending to hear it. But like I said, if you both want it to be in front of the special master, I'm fine with that as well.
The state's preference is to have it be heard today. It's kind of described in the JCCR. The protective order is holding up the production of documents and things. So we'd like to get things moving.
Meta's preference is for us to proceed with the protective order today and have the argument before Your Honor and proceed with discussing it.
Okay, it seemed to be, by the way, you all submitted things, but I wanted to double check. Okay, so let's go to JCCR. State, go ahead, set forth your position why the court should adopt your dates or some modified dates if there's been something in the intervening time that the court should be aware of. Go ahead, please.
Sure. In terms of the date, Your Honor, again, Michael Gayan for the state. I guess there are a number of issues. First, it's not only the dates. I think the parties are in general agreement on the basic amount of time for all discovery, but the state is asking for what I'll call a normal schedule under the NRCP, and Meta is asking for kind of a 10-month fact cutoff and then 5 months of expert discovery where no other fact discovery would be permitted. The state objects to that, believes the normal schedule under the Nevada Rules of Civil Procedure would be more appropriate for this case, and that's what we're asking for. In terms of the actual dates, they're on page 22 of the JCCR. Those are the state's requested dates. One thing that I do want to highlight, and I did not see it in the JCCR, and apologize for that. But in terms of the dates and trial dates, and I heard the court's comment about the amount of time for trial, and that is always hard to predict, especially in a complex case. At the outset like this, you never know how the discovery will turn out, dispositive motions and all sorts of other things that might impact the evidence. But as a reminder, and I brought a copy of it with me today, the stipulation to consolidate these three cases, they are still three separate cases for purposes of trial. I know we consolidated that, and it's been a while since we discussed it, but this is paragraph 11 of the stipulation entered on August 1st, 2024. Paragraph 11 specifically provides that the three cases, it says the lowest case number of the three cases for all purposes other than trial in order to avoid unnecessary cost or delay, et cetera, et cetera. So just a reminder there, and we forgot to put that reminder in the JCCR, but they are three consolidated yet separate, at least for purposes of trial. And so the state's asking for three. I think it would be appropriate for three trial dates since we're here at the Rule 16 conference. And obviously the stipulation provides, and the discussion was at the time, that both sides retain the ability to ask for a combined trial down the road. But today is not the time to make that decision. I think it'd be appropriate to set three separate trial dates, and the state's request would be kind of in reverse case number order: Instagram, Facebook, then Messenger, on successive stacks, and possibly even slight adjustments to the schedule for each of those cases. So this is the page 22. That's the state's position for kind of the first case to be ready for trial, and then maybe it's not great to have all three deadlines the exact same in all three. Maybe it is, but those are some issues that
You're correctly anticipating a question the court was going to ask, because I look at JCCRs, right? Because JCCRs are supposed to trigger dates for trial or trials, even if they're bifurcated trials or separate trials. When I was reviewing this, it appeared that the parties had already agreed that there was going to be the one set of dates, regardless of trials kind of being, whether they were going to be in successive, partially combined. Stay tuned on how that's going to be. So you're raising something different if you're trying to say there's a whole new set of dates, because then this court's analysis is going to have to be possibly different, right? Because, and I don't have the benefit of having different sets of dates for other cases, but let me hear Metis. So I'm already explaining one of the things when I was looking at this, I was like, oh, this is easy because you all want all the same dates and everything was going to just be done.
So this is the first time that we've heard the prospect of trials being kind of requiring different dates in terms of the schedule and the order that they're suggesting that the trials would go in. They have mentioned, and I do agree that there is the reference in the stipulation on consolidation that there may be a time down the road where the parties may take a position about consolidation of trial that may be different, but this is the first time, and we did not discuss during the course of the JCCR that they would require different dates for different trials that would move forward. Meta does not agree with the proposal that's been put forward regarding the trials, but also thinks that it's premature to address that, having not had any discussions about difference there. But what Meta does believe is that the proposal with regard to dates that they put forward makes the most sense for the purposes of this case, and should be entered based on the JCCR that we've kind of put forward and put in front of the court right now, for several reasons. I think the big difference in terms of thinking, both parties have around the same amount of time for discovery that they put forward. The one issue that we differ in terms of opinion is with regard to the expert discovery happening after fact discovery has concluded. We think this is going to be a case that presents complex, cutting edge, and difficult expert issues that are going to need to be addressed, and it makes sense for the factual record to be closed and the experts to be able to opine on that factual record at the time that expert discovery opens. They can provide their expert reports with the benefit of a full factual record. They can be deposed during that expert discovery period in the way we'd anticipate that they would be in the cases that are going on nationwide, which does include fact discovery concluding and expert discovery launching. So that's one slight difference. We think it just logically makes sense for the purposes of this case. But I think the complexity of the expert issues relates to the proposal that we have for the longer term schedule, which includes a proposal for briefing regarding expert issues, as well as separate briefing regarding summary judgment issues, which, as we saw at the motion to dismiss phase, required quite a great deal of argument and argumentation around difficult and challenging, relatively new, cutting-edge issues in the law. And so what we've proposed is one that Meta believes is a rational, reasonable amount of time for the court to be able to deal with those post-discovery issues prior to dealing with the complexities of a trial, or as the state is proposing, something more complex than a single trial for the purposes of this case.
Okay, so let's circle back. First off, I'm going to confirm that there's at least one typo in here. 2024 is passed. Page 23, line 5, final motions to amend.
That should be 2026.
Um,
Oh,
No,
no, actually,
that is
that's
not a typo.
Sorry.
what was
I'm
that?
wrong. I'm wrong.
Was that, have you already agreed that that's all passed?
That is not agreed to. That is Meta's position that
Oh.
that the state should not be allowed to amend pleadings, and the state disagrees with that. So I apologize for not flagging that issue as well. The state, like I said before, the state wants the normal schedule under the NRCP. The state objects to, and I understand the reasons for Mr. Sneed arguing for a different structure to the discovery schedule and pretrial schedule. But I believe those sorts of things were likely considered in the 2019 rule amendments, and we have rules here in Nevada, and the state would like to follow the rules that we have and believe we have a right to those, unless there's some, strong need to deviate from them. And I don't believe that is the case here. One other comment I'll make, I guess two actually. The state believes for consistency and efficiency, all three cases should have the same pretrial dates. It's just for 3 different trial dates because we've not agreed to consolidate for all purposes yet, other than trial. So just in case that, I know I kind of suggested both options, but
Okay. So let's circle back and I'll deal with the pretrial memo issue at the very end, because that's kind of like a minor thing that not have. Okay. For plaintiffs, where I was going to go. Okay, so it looked to me, I thought the December 2024 was typo, but it's not. It's, you want the court in July of 2025 to retroactively say it's closed?
Well, what our position is that under the rule, under NRCP 15 for amendment as a matter of course for the pleadings, the time frame for that has already passed. That is concluded. And so all Meta is taking the position in saying on this date is saying that if the state would like to further amend their pleadings, then that would require a court order, and it couldn't be done without further court order. That's the differentiation that we're making with that statement. And we're saying that that timeline for when the state would be able to make that amendment has already passed.
I think, Your Honor, based on those comments, maybe there's some miscommunication.
Yes,
Normally in Nevada, under our rules, we have just a deadline, the last day for parties to seek leave to amend, either by stipulation or court order. So that's all the state is asking for, that normal deadline. And we're asking to make it, and in our expert section, because of the complexity of this case, we're asking for initial experts to be disclosed 120 days before the close of discovery, instead of the normal 90, and then rebuttal experts 60 days thereafter, and then this leave to amend deadline, which is normally 90 days before the close of discovery, to be 120 days before the close of discovery, to track with the expert adjustment that the state is seeking.
Okay. Let me circle back on a different question, then we'll go to each of these dates. I didn't see that plaintiff had a proposed trial date. Were you doing because I see your final date for dispositive motions on page 22 is October 30th, 2026. Then the top of page 23 goes straight to defendant's proposed date. They do have a trial estimated date. They have a subpart 7 of May 2027. So were you doing a standard 60, which would put it in January 4th trial stack of 2027?
Yes, Your Honor, and,
Okay.
and while you're looking at that on page 23, Meta has also built in, they've built in 3 separate briefing schedules into their, after their close of discovery, which the state objects to. They have hallmark motions, a full schedule. Then after that's done, full dispositive motion schedule, and then time for motions eliminate to be briefed. The state asked for just the normal schedule and not protracted briefing after the close of
Okay.
discovery. And there may need to be a little more time than a normal case, you know.
I really was gonna start with the trial date because it seems to me the most sense is when both parties feel that this case should go to trial and then work backwards. And the reason why I think it's more appropriate in this case to do it that way is because then I can address the various situations. For example, one of this court's questions was going to be, if you're doing the standard dates, it's fine when there's a limited number of summary judgments, motions eliminate, et cetera. But if you all are going to be doing, shall we say, more than a couple dozen, then I see a challenge to how you can have some of those dates with a trial 60 days after the close of discovery. And I say 60, approximately 60 day, a 60-day stack. That's the reason why I said the January 4th stack is the closest approximate stack after an October 30 deadline, which is why I was jumping ahead to that. Because I see that as a challenge from most of my large litigation cases, which many of you have been on, okay, right, is parties want time to have rulings on summary judgments and motions eliminated before they're knee deep or however deep into their trial preparation. From the court standpoint, I'm fine with it. You ask for it, we'll find a way to make it happen. However, experience tells me people may ask for that up front, but then somehow as we get closer to trial, it changes. So it seems to me it's more practical to get deadlines taken care of up front to the extent possible, rather than doing that so that, or maybe this is the kind of case that you want all your motions heard on the first day of trial. Once again, I have to hear from you all. Well, in construction defect cases, that's the norm. Okay, but then in other cases, it's not. Sometimes it are because people want to back in some of their expenses, right? And the court doesn't have a preference. I need to see each case and what makes sense for each case. Okay, so it's a case by case basis. But where I want to go with is, that's why I was really asking about the end of discovery to trial, and then I'll deal with your nuances on how you all want things structured, right? But I need to figure out, I think, a trial date and what's your trial date versus close of discovery motion eliminate deadlines first, because we need to know how many they are and what your need is. So would it be a correct assumption that you do not? I don't make assumptions. Would the parties like to have dispositive motions and motions eliminated the first day of trial, or would you like them based on when they are filed or something different?
Your Honor, on behalf of the state, we would prefer rulings, or at least hearings before the first day of trial.
And Your Honor, we would certainly prefer rulings and hearings on the motions that we're discussing before trial, because we believe that it is very likely that your rulings on some of these issues may have an effect on our trial preparation.
I appreciate, okay. I'm gonna give you both that you both think I'm gonna rule one way and not gonna have a need for a trial. We just.
I thought you might go that far.
I thought that's why, well, you weren't going that far,
I
but I
might
thought it was
believe that,
coming. Okay.
but it would have a change, it would certainly change how we.
That's a given from both sides. I really. It's not your issue that my 8:30 took, and then as you saw that I also, anytime we have a process, at the beginning. I want to ensure, well, every case I want to ensure everyone has a full opportunity to be heard, but some of my cases this morning took a little bit longer than originally anticipated. So I want to make sure you get your time, and I also have to be cognizant of state and federal law. Okay. So jumping ahead, I think does anyone disagree that I need to deal with trial dates first and then work with some of your unique aspects because
Your Honor, Michael Gayan for the state. No disagreement. I believe I heard the court say January 4th stack would be the first. And realistically, looking at the state's proposed dispositive motion deadline of October 30, 2026. I've unfortunately many times had a briefing schedule like that during the holidays. It's not always the most fun. So I think realistically, and my co-counsel reminded me that in Judge Delaney's court, we have the SNAP trial starting January 4th. So I think
oh,
the state,
January 4th, 2027, thanks.
yeah, so the state's request would be to be on the court's next stack, which if it's a 5-week stack, I think would be February 8th.
So do I have the? Thanks, appreciate it. Okay. So let's look. That's February, and that's the other thing. And whenever I see January's dates, I remind people, do what you want to do to yourselves during the holidays. I mean, and that's what
We would not want to do.
okay, particularly when you have out-of-state people and you've got flights and you've got a lot of different things going on. So, okay, so to answer your question, counsel, for the state, the February stack starts February 8th, 2027, okay, which would still put, depending when you file motions, it still puts you right towards the end of December-ish, right? Likely for hearings. Is that really what, or am I realistically looking at March versus May for trial dates?
Your Honor, for the state, we would request the Instagram case be set on the February 8th stack, Facebook on the March stack, and then Messenger on the stack after that, whatever they are.
Okay. So you're still saying about February 8th, okay.
Yeah, yes, Your Honor. And I think we can work on what the briefing schedule might be. And I know we're working backwards, and so we would look at where the motion deadline is and maybe have a little bit more room built in so there's time for briefing and hearings.
And that's where I was going. Are you wanting still to have a 60-day time frame from close of discovery to trial, regardless? If I'm just use the word trial, because remember, you already have orders from this court, including yesterday, right? Which says trial date in the singular. Okay, and we'll address whether that means back to back to back on stacks, and that's still a trial date, but okay, we're not getting to those nuances yet, folks. Okay, so, but are you still wanting 60 days from close of discovery to trial, or are you thinking you're gonna want more like 90 days?
Your Honor, on behalf of the state,
You put less than, I mean, your motion eliminate date makes it impossible for me to do your trial date, just FYI. Your motion eliminate dates for April 2nd, 2027
Yes,
means they won't get set until count approximately 28, 30 days, right? There's no way, and then you're saying, let's put it this way, there's no way to be consistent with your request to have hearings and rulings to start a trial in May with a May stack and then have your motions eliminate deadline be April 2nd. You're cutting it
Understood, Your
really,
Honor.
really close. I mean, technically my May stack actually starts, well, depends if you really mean May or you meant
Well, we
April that
were-
goes into May, but you just put May. So if you're talking May, that really is my April stack that starts April 19th and goes to May 21, which really does not give you what you just told me a few moments ago. You understand, these are some of the things I'm just trying to walk through. That's the reason why I'm starting with trial dates first, because
Right.
then we can see what people's real needs are for your dispositive motions, and then I deal with whether it gets broken down to some of the requests. So,
On this point, Your Honor, thank you we were estimating May 2027 based on April date, but I understand based on the trial stack schedule, it might require it to be further later than May. Our goal is to be realistic in identifying briefing schedules that are going to work. If we're going to need hearings for each one of these, we want to be realistic. To the extent it needs to be into June, we would definitely take the position, we'd rather start then than try to crunch everything that's happening before then.
maybe the easiest way to phrase this court's question is there an agreement between the parties for the last date? Okay, motions eliminated are your last date under Nevada law. right? Okay, and yes, this court normally does the 6 weeks before trial because, right, 6 weeks unless otherwise ordered by the court, right? So we normally do the 6 weeks. Oh, sorry, it's the 30 days, but you can do the 6 weeks. I usually do 6 weeks for motions eliminate to give. And I just misspoke a second ago, but I give 6 weeks for motions eliminate to give the time before trial starts, so that you're not right upon a trial date. So really where I'm trying to get is how much time do you want between the date of filing motions eliminate and dispositive motions and your trial date? Are you wanting 60, 90 days? I mean, it seems to me you all can come to an agreement on that because that's really what you're doing to your selves on how quickly you want to get things turned around hearings. And remember well, I would love to say I'd rule every single thing from the bench, but I have no idea what's coming down the pike to me. You know what I mean? So you got to build in something there.
Your Honor, on behalf of the state,
I'm sorry, we do 8 weeks. I said 6 weeks. I know I misspoke a second ago. My apologies. I was like going, I know I misspoke, but it's been a very long morning on a variety of different issues. So, sorry. So yeah,
yeah,
we do the 8 weeks before the first day of the trial stack. So I will tell you under what you both have proposed, under your trials, your current trials, if you did 8 weeks, plaintiff, your motion eliminate date gets you to November 9th, 2026. Defense, yours gets yours to, well, you specifically asked for 4/2/2027, so that's not 8 weeks before a trial stack. So how much time do you want for that so that you're actually getting rulings, right? Hearings and rulings before you're doing trial prep. Like I said, I'm fine with you want to cut yourselves really close, okay? But it doesn't sound like that's what I'm hearing the parties want. So let's hear what the parties want.
no, Your Honor, Michael Gayan on behalf of the state. Just based on the state's dates in the JCCR, our final date to file dispositive motions that we propose is October 30, 2026. Our request would be to keep that date somewhere very close to that if the court is considering the February 8th stack, and that would give us more room, I believe about 90 days, maybe even a little bit more, to have possibly a more comfortable briefing schedule for all of these motions, and then also time for hearings and hopefully rulings before trial commences. But just so it's clear, the state objects to Meta's proposed schedule, which is 8 months or maybe more between discovery, cutoff, and trial.
Okay.
To accommodate 3 separate sets of briefing. The state believes that's excessive.
So very, very minor point, can't be on 10:30 anyway, because that's Nevada Day.
So
Say holiday, but
what is that, November?
no, I'm sorry. You have a last day to file dispositive motions, 10/30/2026. 10/30/2026 happens to be Nevada Day in 2026. October 30th happens to be not the real one, but the celebrated one, as we all know, because the real one's October 31st. But that's the celebrated one for 2026. So regardless,
To the first week of November.
yeah, that's a minor issue. But if you did a motion eliminate date where that really puts you, sorry, dispositive motions, that puts your dispositive motions then would probably be set in the first week-ish of December to the second week of December, right? Which, once again, that's where I'm going. Okay, so let me, I'm gonna jump ahead. I'm gonna tell you where I'm thinking of a trial date, okay? Balancing these and looking at everything, I'm really thinking of putting you in March or April is really, and the reason why well, for everything that we just discussed, I'm thinking March or April, because realistically, putting your dispositive motion deadlines and your motion eliminate deadlines to be heard right around mid-December to the first week or two in January, I would believe I'm gonna get requests to move them anyway, okay? And you all are gonna tell me you have weather issues, you have family scheduling issues, which I'm all empathetic to all of that, right? So it seems to me, why schedule something if you all are gonna tell me? Okay, now if you tell me right now, okay, by the way, I'm here. I will be here that last week in December. I always try and make, to my knowledge, okay, I plan to be here.
That's my experience.
Yes, you know, because I try and do it because some people, there's those emergency issues, and I'm one of the few judges that's, let's just say, I'm generally here, okay? I can't make any exceptions. I don't know. I might have a family event or whatever, but I hope to still be here, right? Okay, but where I'm saying is, Most people don't want to do that to themselves. So if I look at that, that really puts me in March or April for your trial date and then working dates backwards from that, taking into account people's various positions on dates. Okay, so let's just work on March or April. Which one are you all each gonna argue for?
Your Honor, the state would ask for March and.
And just to let you know, that's, I'm sorry, I'm interrupting you, but I'm, so we're clear on which March I'm talking about. That stack starts March 15th and goes to April 16th. So yes, I do appreciate it goes through some people's potential spring breaks, but realistically, at some point, I gotta set y'all for trial and.
Well, it's possible the state prevails in summary judgment and we won't need that.
I knew that was coming, okay.
Let me check my cat.
We would argue that April would be the more appropriate time frame. Make sure that we wouldn't get scrunched during the pretrial motion briefing and would propose that that would be the more reasonable time frame.
And Your Honor, and this is Michael Gayan for the state again, just part of the reason is the state's and I apologize for the JCCR not making this clear, but the state did not intend to kind of waive or capitulate to a single trial by failing to call that out in the JCCR. I was unable to attend the ECC. We've had some turnover on the state's council side, and for whatever reason that distinction got missed as I was out the last week of May for a funeral. So I apologize for that. The state did not intend to waive its right to have 3 separate trials.
One thing I would note on this, to the extent that the state has maintained that they retain the right to pursue separate trials, we don't disagree with that. But we think that at this moment, it makes sense to proceed with setting one trial date. The state has its ability to seek to bifurcate the trial or seek relief about how many trials they want at a later time. But at this point right now, I think the case is consolidated for all purposes other than trial right now, and we should set one trial date, and then the state can pursue the relief it would like later down the road.
Your Honor, for the state, I guess that just flips the stipulation and order on its head. It says 3 separate trials, and the parties reserve the right to seek a single trial later. If Meta wants to do that, I think a motion, properly noticed motion would be appropriate, and we're just asking at least to keep that open.
Here's what I'm gonna do. I'm going to give a quote trial date, regardless if that means, I'm not going to take a position at this juncture, whether that means back to back 3 cases starting on that trial date, but I'm going to give you a solid trial date. That's going to trigger your pretrial memo dates. That's going to trigger all of your final dates, because that's consistent with the JCCR to say that you want your discovery cutoff to be on one solid date. You haven't triggered 3 discoveries. You don't have 3 motion eliminate dates. You don't have any of that. So that's consistent with what you've submitted to the court. It's also consistent with the order I just signed appointing a special master. Okay. And it's also consistent with the prior order where you reserve the right to do it as 3 back-to-back. So I'm not saying how that method of trial is going to be, whether or not there's going to be combined with all 3 case numbers, but I am going to set all your dates with a concept of the trial or trials will commence on X date, and everything's going to be triggered from that initial date. I think that gives you consistency with everything that you're going to put before the special master. Okay, and once again, remember, I'm using the term special master because that's the term currently I'm supposed to use. Court takes no position whether or not it's an appropriate term to use. That being said, I don't think that's what I'm going to do. Anyone want to be heard further on that?
Your Honor, all I would say, Michael Gayan for the state, and I appreciate the court's comments, and I will leave that at that. And dovetailing with the special master, I believe there were a number of other issues in the JCCR that might be more appropriate to be heard and resolved, or at least discussed with the special master first. So I guess my proposal on this trial situation would be the parties can meet and confer. We've worked well together before. We can raise it with the special master down the road and file a motion with this court if
Wait a second. Trials are specifically reserved to the court trial date. Remember, that's in there multiple times in your special master, right? Trial
Understood.
date. Okay. So are you saying that you don't want me to resolve your discovery dates and your motions to amend dates?
No.
Oh, okay.
The only
I
thing I was
misunderstood.
referencing is like deposition limits, for example.
Oh.
That's a dispute in the JCCR. That might be more appropriate for the special master to discuss. For the
Okay,
parties to discuss.
so here's what we're gonna do. Okay, March 15th, 5-week trial stack is your trial stack. Okay, I think that balances March 15th, 2027, that goes through April 16th. Okay, that allows an opportunity to file motions to get heard at the beginning of the year, give you time with regards to getting those motions heard, both dispositive motions eliminate. It meets everyone's discovery needs, because realistically, regardless of which way I do discovery, you both have a close of discovery, while one calls it expert, the other calls it close of discovery, of September 30th, 2026. It really takes into account the holidays, so March, okay? And that means we are gonna work with some unique dates a little bit, because it's giving you more time between the close of discovery and the trial. But realistically, I don't find a January date is gonna meet your needs because of all the motion practice you're going to do, and that no one's gonna wanna be telling you that they're gonna wanna be working during the holidays, which then puts the February issue, which really doesn't eliminate that issue because you're still doing it and you're prepping everything, and it's still gonna get the same thing. So March meets the needs, gives everyone sufficient time. And so now let's work backwards. So March 15th, 5-week trial stack for trial or trials, but all dates are going to be triggered with a March 15th. So when you get your trial order, it's going to say March 15th, and we'll work on some language for trial, maybe per NS, okay? But all dates will be triggered off that as the commencement of trial. Anyone want to be further heard on that? If not, I'm moving on.
No, Your Honor.
No, Your Honor.
Okay, so that means that we need to rework. Well, let me give you my initial thoughts on all your other issues, and then we can work out some dates, because realistically, well, okay, so this court is not inclined to break out discovery into fact discovery and expert discovery. The court has found when we've done that in the past, it gets merged and it just really ends up with more issues than really ends up happening. Because what is fact discovery? What is expert discovery? What is potentially for fact discovery that may go to some expert discovery? Particularly since your pending motion has some issues with regards to what may need to be done in advance. So I think the cleanest, clearest way is to follow the straight rules, and you get a discovery cutoff. You both seem to agree with September 30th, 2026. Is anyone asking me to do something different than September 30th, 2026?
No, Your Honor.
No, Your Honor.
And you understand I'm building in extra time for your motion practice versus, okay, so your discovery cutoff is September 30th, 2026. Okay. So motions to, now, okay, motions to amend in light of the statements by each of the council. I mean, can I get a clarity from Meta? Are you saying that the leave to amend should not be the 90 days?
Our position is essentially that that we did not want there to be leave to amend without further court order, as in the permissive leave to amend under Rule 15, later than what is allowed already under the rule.
Okay, counsel, do you really dispute that? Because you can seek leave to amend, right? I mean, you can't file an amended party. You already passed your complaint, they've already answered. I mean, is it really an issue for you? As long as you have leave to amend through a date, that date being discussed in just a moment, not a retroactive date?
Yes, Your Honor, we're just seeking the normal deadline to seek leave to amend under the NRCP, so I don't know.
90 days before discovery cutoff date is the standard.
That works for the state, and I think that would be June.
As long as
30th.
it's leave to amend it, right? It's not an automatic amendment. Well, they don't have the right of an automatic amendment anyway because of the procedural posture.
They've amended and yes, Your Honor, that is
So
fine.
if they want to add parties, they've got to ask the court anyway. And if they want to file an amended complaint, got to ask, right?
Yes, Your Honor.
As long as we're not modifying 15, okay, so 90 days before the end of discovery, I'm going to let. It works out still to be June 30th, doesn't it? Oh, good, I worked this out well. Okay, I did what I thought I did. Okay. So that means June 30th is your motion to amend with leave, right? Okay, straight 90 days. Now. So if you give new discovery, giving motion to mesh, initial expert deadlines. It's not normally 90 days before the discovery cutoff. Which, although here I'm more inclined to make it later in June. And the reason why I'm inclined to do it later in June is I think you all are going to have some I would love to say that this case is gonna go amazingly smooth, very, very quick, right? And you'll get straight into experts. I have rosy colored glasses. I'm also a realist. I really anticipate you're gonna need a little bit extra time to do your experts, unless you all are telling me that you're doing the same experts that you've already done. I don't want to say across the country, but shall we say in other places? And here's where I really do need a little heads up, because as many of you know, there's been some cases that this court has handled where parties have wanted to use experts that they've already used in other litigations. In fact, they've even asked the court if they could use the straight same depots, et cetera, right? Okay, and introduce them in lieu of live testimony. Okay, in whole or in part. I don't know what you're thinking. I would love my crystal ball to tell me. But it seems to me if I put it somewhere in towards later June, I'm not a split the baby kind of person, but realistically, I was thinking about mid to late June for your initial experts, because I see realistically, you have a lot of documents to go through to get to your initial expert deadline. But once again, I don't know if you're planning on using experts that you've already used, and maybe that's not necessary. So can you please enlighten the court?
Well, I don't know about the state's plan in terms of what they're intending to use in terms of the nature of expert witnesses, but I can tell you that these proceedings have been going on across the country, and in each of the jurisdictions that I'm aware of. One thing that I do want to flag is that the plaintiffs put forward their expert disclosures first. And in response to that, defendants were able to see what they've put forward in terms of their expert theory, particularly in this type of litigation with the nature of the claims that are here in this case. And defendants had a second date approximately 30 days later in most places, but it has differed in different places to be able to respond to it. And then the plaintiffs got an opportunity to provide rebuttal disclosures after that. And that process has worked well in other jurisdictions. And we think that's the most appropriate way to structure the expert disclosure process.
Well, why do you need it here? Because Nevada's not that way, right? Nevada's different. Nevada's, right? Changes to the NRCP, despite extensive changes in 2019, as I mentioned back March of 2019, right? That date wasn't changed. That concept, and there probably is at least one person here in this courtroom that might have been on the panel committee or submitted. Might have been, okay. And so I'm not saying any names, I'm just saying is that issue has come up in the last 14 years I've been on the bench. Wow. Yeah, so, and it's never changed. I mean, Nevada is Nevada. And you're litigating in Nevada. Okay, so is there a reason in this case? I appreciate other jurisdictions have taken a different position, but here we haven't, unless there's by agreement by parties. Now, oftentimes there's an agreement between the parties, but here I don't have that. So is there a specific reason here that they would need to do their disclosures first before you can do your disclosures that I should be considering?
Yes, Your Honor.
Okay, go ahead, please.
And it's not the default in every jurisdiction that it is kind of tiered in that way. In some jurisdictions, the parties have come together. Other jurisdictions we've litigated.
I did practice for 2+ decades before being on the bench. So yeah, I am familiar with multiple jurisdictions around the world. Go ahead, please.
Yes, Your Honor. The nature of the expert reports that are happening in this case and the expert disclosures that are gonna take place in this case are going to bring to bear a great deal of the discovery. For example, there are millions and millions of documents of discovery that have been provided. So far, there's a great deal of testimony that have been elicited. And the experts in the case, particularly the different types of experts, we anticipate that they're going to have a wide variety of types of experts. We've seen that across the country, and they have brought to bear specific references to the portions of the large scale of discovery that's present in this type of case. The nuances that come up with the kind of discovery that's pointed to and the basis for the opinions that are put forward by the plaintiffs are going to drive how the defense experts analyze and respond to the types of issues that are here. So it's not the case that we can just imagine and automatically get what the state is going to put forward in terms of its expert theories in this case, based on the types of theories that are going to be needed and based on the breadth of discovery that's in this case. We would be guessing in many ways if we were having to respond to plaintiffs' experts and theories before we saw what their theories were by their disclosures. And so that's a big part of the reason why in every other place that I'm aware of, and I recognize that Nevada does not by default require this, but this is a complex case that presents novel and different issues. We've seen that in the preliminary injunction proceedings. We've seen that even in the slight skirmishes with the jurisdictional discovery and the discovery that was provided there. We're looking forward and anticipating that the breadth of discovery is going to be massive. And what is going to have to happen is essentially for defense experts to guess at what the plaintiff's expert theories are going to be without the ability to be able to see and then respond to them accordingly as to complex issues like causation and medical causation and all of the things that go into backing up the claim that these platforms are addictive in some way and has presented the types of harms that the state has alleged in this case across 3 different platforms that are involved in this case as well. And so being able to understand, well, there may be a different theory that's been put forward for Instagram than is being put forward for Messenger, than is being put forward for Facebook. And their experts are going to drive a great deal of what that looks like in terms of how we defend.
I got it. Okay, I'm gonna have to shorten you up on some of these because you can appreciate it is
I
the
understand.
hour. I mean, I can welcome you back at 1 o'clock and we can take a lunch break, but we're gonna have to get this all done like in about the next 15, 20 minutes, folks. So, and I
Happy to
want to
do
give you
that.
all the time, so.
I don't know, unless the court's considering doing the bifurcated or staggered disclosures, I don't know that I need to say anything else.
Court considers everything, listens to everyone to ensure everyone has a full opportunity to be heard to make the best well-reasoned decision for each specific case. No surprise, I'm gonna say, I mean,
Then I will make 2 quick points. First, counsel's argument that Meta is facing similar claims across the country cuts against them being surprised by anything the state is doing in this case. And second, that's what rebuttal expert reports are for and why there's an opportunity to do rebuttal. They do the best they can with what they've got. And to the extent the state does something that they did not anticipate, they get to rebut it. And then we go forward. That's what happens in every case in Nevada. So welcome to the silver state. That's all I would say.
okay, and the court's got, I mean, there's such a plethora of case, I mean, on that equal opportunity to do your initial experts and then to have your rebuttal experts. I'm hearing what you're saying. And like I said, that's one of the reasons why I wanted to hear if you all were using stock on both sides that you already knew about. Is that something the court should be considering? I'm not hearing you saying that. I'm not hearing anybody really telling me where you're going yet, but it's okay. But I'm not seeing that there's a reason for the state to be required to disclose their experts first that would give this court the good cause to change what is specifically set forth in the rules. And so therefore I'm going straight with the rules, which means same expert initial disclosures, which means I am going with now herein lies a question. Normally, oftentimes the motion to amend date, right, is triggered with your same initial experts, but counsels for plaintiff, you asked for June 2nd versus June 30th. And realistically, the date you're asking for is within, which under the rules would be pretty much the date that Meta wants. Is there some reason you're telling me I should do it earlier than the standard of June 30th?
Your Honor, Michael Gayan for the state. The reason we asked, the state asked for a little bit more time or a little earlier initial experts is to build in more time for rebuttals, because it is, we do anticipate more than, you know, a couple of experts per side here. So there might be a fair amount of work there, and a 30-day turnaround on rebuttal reports we anticipate would be challenging in this case. And so that's why we backed up the initial deadline a little bit more than the standard 90.
Okay, but if I counsel for Meta, I mean, do you concur with the concept that you want more between the initial and the rebuttal?
If the court is going to proceed with the simultaneous initial, we do agree with the concept that there will need to be more time between initial and
Okay.
rebuttal.
So let's do this. Right now, we're gonna need to do some math in order to figure out, to make sure it's consistent with your other deadlines. Give me. Okay, so. Gotten your motions to amend 90 days. So you've got 60. Okay. Well, I'm gonna give you all a choice. You have an option A and option B. If you both agree to option A, one of them will take, one of them is not gonna rule on it, okay? Well, so I can give you your motions, okay, your initial experts disclosures, I can give you the 60 days that you want between the two. But tell me when you want the initial experts disclosures, because I'm leaning more towards mid to late June, closer to what Meta's requesting, but Meta only requested the 30 days for their rebuttal.
Well, we requested, right, in the scenario where there was plaintiffs, defendants, and then rebuttal, there were
Right.
30 days between them.
Right, but
But
you only
I
said
think
plaintiff's rebuttal, you didn't really give you defense any rebuttal, you didn't give yourselves any rebuttal.
No, because the rebuttal would be part and parcel with our response to the plaintiff's initial,
But
so there
that's
would
not-
be no need for a greater amount of time. So under our theory, we were rebutting within our defense expert reports.
I'm hearing what you're saying, but that would cause large amounts of confusion because of the distinction between what needs to be in an initial expert report versus a rebuttal report if somebody tries to file a motion limine with regards to some of those issues. So we're gonna keep it clean and clear, okay? So this court doesn't have a preference. I can give you 6-2 and 8-1 as plaintiff wants. I can give you mid-June and then add 60 days because I still built in enough time because of your trial date to get you where you want to be. So you can have 6-2 and 8-1, or you can have 6. And 8-14, right? $30, okay. No, they're gonna want their spouse because that puts them right to Christmas. Okay. Someone propose a date that you really want with your 60-day dates. I mean, like I said, I'm fine with some date anywhere from the beginning of June to the July one that Meta wants and giving you 60 days. We'll just need to move your dispositive motion deadline, right, to get you where you want to be.
Yeah, Your Honor, Michael Gayan for the state, in light of kind of what's going on here today, the state's preference would be the mid to late June and then 60 days thereafter for rebuttals. And then adjust the, that maybe the cutoff a little bit. If the main concern there is to have enough time to take all expert depositions after rebuttal reports come out.
Yeah.
110, okay, because let me jump ahead, your dispositive motion cutoff. You're not normally, if I gave you initial experts on 6:30 and rebuttals on 8:30, your dispositive motion normally would be 11:30, which is not what you're gonna want, because it gets you right back to your holiday time period, because that means things will get set, right? Which means the latest I could probably do it is 12:10. Let me make sure I did not pick a. Yeah. 12:10, I could do your dispositive motion cutoff, which means hearings would be the beginning of January, which still gives you enough time with your trial date. Right? So do you want June 30, August 30 and dispositive motion cutoff of 12:10, or do you want something different?
Right, so that would leave us.
Your Honor, could you run through
Sure.
those dates one more time, John?
Normally, your initial expert deadline would be the same as your motion to amend. So if you want for consistency, initial expert deadline, if I gave you June 30th, we could do rebuttal experts August 30th. I'm just making no, excuse me, not August 30th. August 31st. So it's not a Sunday, so August 31st, and we could do your dispositive motion on 12. Well, 12:10 or 12:11, it really doesn't matter, okay? Which puts the time for hearings on your dispositive motions after the beginning of the year in January, which still gives you your time for your trial date to get things heard and get prepped. Now, you might ask me that you really want dispositive motions earlier, which is gonna be fine too. I'm just trying to give you timeframes. It gives you your 60 days.
So two things. The hesitation we have is that August 30th would lead to the close of discovery being September 30th. It would lead to a month for us to do all the depositions of the experts, if I'm not mistaken.
Yeah, Your Honor, for the state is fine with all of the dates the court provided, but like Mr. Sneed just said, I think we would need to move the cutoff back a little bit to make more room for depositions after the rebuttal
So
expert.
do you want 6/2? Like I said, pick a date in June you want, folks. I mean,
Or we could just stick with the dates the state proposed, 6/2 and 8/1.
the court's fine. Like I said, the court's fine with, I'm fine with any date in June and a 60-day date that you want between initial experts and rebuttal experts. Realistically, if you all agree on a date, I'm gonna put it in. So what makes sense to you?
Yeah, I was thinking that if we did June 15th, like the middle of the month, and then August 15th for the rebuttals, that would give us a month and a half to be able to do the
August
depositions
14th
after.
or August 17th, since the 15th is a Saturday, but that's fine.
August 14th.
No objection from the state, Your Honor.
So 6/15 for initial expert deadline, rebuttal experts, August 14th, and we're still in 2026. Okay, dispositive motion cutoff. Dispositive motion cutoff. Normally under these dates, it would fall somewhere around 11:30 to 12:10 or 11. Sorry, 12:11 because 12:10 is a weekend as well. Which means that gets heard in January. Which still gives you the time with a March trial date, March 15th.
Would Your
Got it.
Honor entertain the prospect of a briefing schedule with regard to the hallmark motions, the expert motions that would take place before the expert, before?
You're getting straight motions. You're getting straight motions. I mean,
So the time
I do not see a reason. The challenge in breaking it, particularly in this case, if you all. I don't see good cause to change it from the standard rules, particularly because. Working with the various dates that you want, working with the fact that I've got 3 consolidated cases. You're gonna end up with certain motions that realistically, somebody is going to probably tell me. Guess what? We've got this motion is gonna relate to this motion. We really, it's gonna get jumbled up. So if I do it all on the same date, then you all are filing everything that you want this court to hear in summary judgments, whether it's a series of partial summary judgments, one big summary judgments, or however you're doing it. You can always file them earlier, right? You can always do your own self-imposed breaking down, but if the court does the breakdown that you're suggesting. Historically, when I've done that to accommodate people, it just has not really worked well. And I don't see in this case that anyone's provided me any reason why it should be that way in this case.
argument would ultimately be that the differences in the expert lineup might have a material effect on the summary judgment motions that would be put forward, because we maintain that there are certain things or certain features of their claims that wouldn't be able to proceed on the basis of an exclusion of.
That happens in every single case. Realistically, it happens in every single case, and you can self-do that because you can file your expert motions earlier and ask them to be heard earlier. Realistically, just I'm saying for the court to do that imposes a stricture that I don't see makes sense in this case when you all can do it yourselves. And so the answer is you're going to get one summary judgment deadline, okay? I'm glad to accommodate you so that summary judgment deadline doesn't make it that you're hearing motions right around the holidays, the last 2 weeks of December. I'm fine with mixing around dates there, the best interest of the case and to meet all the attorney's needs, right, and your client's needs. I'm fine with that. But we do need to have one set of summary judgment motion deadlines.
Well, I think our position would be the later one of the two that you proposed, to allow us, if we wanted to proceed in the fashion that we've described in terms of filing a motion regarding the experts in advance of the summary judgment deadline.
And Your Honor, for the state, I think Mr. Sneed's referencing December 10th. The state's concern with that is there won't be any real room to have an extended briefing schedule with the number of motions and the complexity of the issues. I think the state's preference would be to pick the second or maybe third week of November for a filing date, with the expectation that the parties would likely get the normal hearing notice from the clerk and then do a stip in order to set a little bit longer briefing schedule. 14 days might be tight for the number.
Can't you all, okay, can't you all agree right now then that oppositions are 21 days? I mean, I will not, let's be clear. The court is not going to give you OSTs where this court's gonna get 50, 60 motions on summary judgments, okay? With this court only getting a couple of days because you all are going to do two wonderful of briefs and so many exhibits and things that you're going to ensure that this court has the proper time to prepare, okay? So do realize we're not cutting short the reply deadline, okay?
No.
Okay,
Not maintain that that's
you're not,
the
it's not feasible, okay?
Yeah.
Unless you're
Yeah.
telling me I'm getting 2 or 3 motions, if you're limiting yourselves to 2 or 3 motions, I'll put that in and you can have some.
No, Your Honor.
But you understand where I'm going, okay? So if you all want to self-agree that you're going to have 21 days for oppositions and that applies to everyone, then we can build in time to do that. If you're, the way you're suggesting for the state, the reason why that's not gonna make sense is you're gonna. Let's just do it now if that's everyone's expectation and pick dates, because if you do it close to the time frame, what's gonna end up happening is you're both gonna say you have schedules that you might not be able to do this date or that date, and it's gonna end up raising issues and potentially impact other dates down the road. Let's get as much as we can get cleaned up, cleared up, so everyone has the same expectations up front. Unless you all can give me a compelling reason that that doesn't make sense, that's where I'm leaning.
Your Honor, that works for the state, and I'll just make an initial proposal then, November 13th for the deadline to file motions, 21 days for oppositions, which would be December 4th. And then either 2 weeks to December 18th for replies, or maybe the following Monday to try to avoid interfering with the holiday week.
Really, so I'm gonna be reading all these over that last week. Thank you. I appreciate that, counsel, thank
Well,
you.
with the hearing sometime in January that works for the court. So no hearing in December at all, of course. I know the court
The
works.
short
very
answer is,
hard,
you
but
know, I'm gonna be doing it anyway in another case, but we're just, okay, so, okay.
No, but maybe the second week of January to argue. Realistically, with the trial, March 15th, I don't think there's a huge rush to have it heard. So obviously the court's very busy. I heard you have your stack starting January 4th. So the department.
So counsel, repeat that. You're saying November 13th for dispositive motions, is that correct?
Yes, and then oppositions on December 4th and replies on the 18th or 21st. That would give the parties plenty of time to provide the court with courtesy copies, and then hearings could maybe be a couple of weeks later. So there's plenty of time for the court to prepare.
Your Honor,
You're not drafting these down.
our position would be that there's no need to kind of jam all the briefing that's gonna happen in before the end of the new year, not even given the trial date being back in March. We'd maintain that we'd propose a mid-December motion date, and then we would have no problem with a little bit of an extension of time with regard to the opposition and reply brief to account for the holidays, but to conclude the briefing in January and then have the hearing in the beginning of February.
And you know what you've done to yourselves, right, on your preparation for trial? And I appreciate both sides thinks there may not need to be a trial because you're gonna prevail on everything that you want to prevail on. But in the chance that that does not happen and you go to trial, you realize what you've done to yourselves for your trial prep time, right? Because then you've given yourself an incredibly short amount of time and you're gonna have electronic exhibits, which means you have to get them to the clerk, right? X amount of weeks in advance, and that's a moving deadline.
Right.
We suggest 6 weeks. Now, the clerk sometimes, depending on how many vault clerks, depending on how many they're doing, might do something different, but that means you have to have everything done and taken care of. So if that's what you're really intending to do, realize that's what you're doing to yourselves. Is that what you're intending to do? Because think of how many documents you might have for trial. Exhibits is usually the largest issue, right? And you got to get them prepared, you've got to get them taken care of, you've got to get them all done on drives, okay? And I don't know if you're going to give this court depositions in lieu of live testimony. We're going to have to find time for that if you're wanting to do it, which means you're going to have deadlines to do your lining of testimony A once versus B once, alternative testimony. Once again, I don't know if you're planning on using people from other matters that you're going to do depots in lieu of live testimony. I've done this enough. I anticipate these things. So like I said, if that's what you want.
Or May for the trial?
No, I've seen the purple and goldenrod trial protocols, but the state's open to slightly more time for the briefing, but I think hearing in February is not a good idea. I'll stick by my original proposal, and if we want to extend it a week or two on the opposition and the reply deadlines, the state's open to that.
No, I cannot do it. 2 weeks, I need 2 weeks. There's no way. Yeah, there's no way.
Something like.
How many motions are we talking about, folks? I mean, just ballpark me. I mean, are we talking more than 2 dozen? Let's phrase it that way.
I mean, it's hard to say without knowing how many expert witnesses, if you're saying that this has to include all the motions that would relate to witnesses.
I
as
did
well.
say that.
Motions. Thus.
All motions for somebody, where I'm trying to go is realistically, right? The reasonableness of doing an opposition extended time, the court's fine with it, that's what the parties, okay? But what we can't do is we can't say, we're gonna bring these all to the court, we're gonna have 50 motions. And, we want them all to be heard 5-6 days later. No, because you all are, unless I'm going to give you specific page limits and I'm going to give you specific page numbers for exhibit limits, which I don't think you want this court to do, but there's 24 hours in a day and there's one of me, and you all have resources of hundreds, right? So, and that's not in any way, I mean, I'm going to be fully prepared, but I'm going to want to be fully prepared, and there's 24 hours in a day. So we've got to figure out these timeframes. Like I said, if you want me to push it back to, you want your trial pushed back to April, then you've got some more. But I'm hearing the state doesn't want to, and so I'm trying to combine everybody's needs here.
Understood, Your Honor. Based on what's been stated, would the state be open to an April trial date? To be able to avoid briefing over the holidays? Because either in this schedule, either the parties are going to be briefing over the holidays, or the court's going to be reading everything over the holidays and then having a hearing first thing in January.
Well, not by what council's proposing, realistically, if you did November 13th, and you did December 4th, and you did December 18th. And hearings then would get set probably the week of January 11th-ish. We would have to set aside some time.
Alternatively, Your Honor, we could back up the dispositive motion deadline. I mean, I propose November 13th. We could do a week before and take time there. That would be the state's preference over infringing on the trial date and moving it back to April.
Okay, folks, we're
We're
doing a lot of different things, and it seems to me, I'm gonna have to politely tell you all, should I see you back at 1:30? So that you all can, in the intervening time, talk among yourselves. Let's see what agreements maybe you can reach, because my team is,
Yes, Your Honor.
I mean, I have like 3 minutes before I need to make sure that they get state and federal law. So of course I'm going to comply. And that's in addition to them being wonderful to agree to stay this late past the noon hour. So 1:30, any reason can't do 1:30? And people,
No reason, Your Honor. We'll chat in the cafe or some.
Is there anything else that we should discuss besides the trial date and the dispositive motion?
can resolve the issue on the experts.
Oh, good expert, yeah. Great.
Oh, you asked me.
We'll work it out.
I just want to be mindful of the time when we come back.
No, okay. But I can give you an inclination on that, so you all can digest it over lunch. Do you want me to tell you my inclination on the other motion? But it's not for argument purposes, it's just gonna be a quick inclination.
Yes,
Yes,
Your Honor.
My inclination is I'm going to grant it in part, and we're gonna find a way to make it an even playing field. Because I think it is practical sense. I think you need to be clear on what parties are going to do, and I think trying to get proverbial, and I really do not like this cliche, but I can't think of something better, horses out of barns, etc. And I don't see that it really is a prejudice, because particularly the way you all are structuring with your initials and rebuttals and stuff is going to give you time. And I think it makes practical sense. I also think it avoids some unintended consequences with regards to litigation in other states, that if I were not to do it, that you might run a risk of somebody saying that they could potentially utilize some document that comes from the Nevada litigation in other litigation. And I would like to minimize that issue. In no way taking any position on any other state. I'm a Nevada District Court judge. Clark County. I'm not in any way implying anything for any other state, any other county, and anything, but I just, when I look at all those factors, I think though we need to work out a means which makes it a fair and equitable playing field for both sides. So that's as much of an inclination I can give you, what you might want to talk about, thinking about what that fair and equal playing field and focus on some of the aspects in their reply. Okay, have a good one. See you back at 1:30.
Thank you.
We are back on the record in case 886 110 and consolidated for most purposes cases there too. So council, I'm just gonna say in parties, same appearances. Does that work for everybody?
Yes, Your Honor.
Unless you want to hear your names again? Okay, that works. Okay. So did you have a nice fruitful lunch where you came to an agreement on some dates and so we could just input them for you?
Yes, Your Honor, we did reach an agreement on the schedule for the dispositive motion dates.
Okay.
We have, sorry,
Let's hear them, please.
November 6th will be the date for filing dispositive motions.
Mhm.
December 4th will be the date for filing oppositions. And January 8th will be the day for filing reply briefs.
Okay,
Be mindful of the holidays that are incorporated.
is that agreeable to council for the state?
Yes, Your Honor, the state has agreed to Meta's proposed briefing schedule, and then obviously the hearing would be at the court's availability.
January 8th, one second, that's, okay, look at this calendar, 1 second, please. Okay, that's a Friday, which means the court, I'm gonna give you a temporary date right now, okay? Just to ballpark it, I'm gonna Thursday, January 21st, and probably Friday, January 22nd is my ballpark. How close did I come to your estimated dates?
I got 2 of the 3, I thought.
Your Honor, I was going to suggest the 22nd or soon thereafter as the court is available, because realistically with a Friday reply deadline, courtesy copies couldn't get to the court until the 11th. And the court needs a reasonable amount of time.
Yeah. That's what, if I say the 21st, 22nd, but realize depending on how many I have, and as we get closer, we might have to play that, but at least that way you have a time frame. Okay, motions eliminate. Any reason not to do motions eliminate the same day as your dispositive motions? I know some people like to stagger them, but realistically, while this is in no way a ruling by the court, some of the issues that were brought up in the Hallmark type ones oftentimes appear in motions eliminate versus motions for summary judgment. The court takes no position whether that's proper or not. I'm phrasing custom and practice. So oftentimes people want the same date for dispositive motions and motions eliminate because they are usually triggered by very similar type things, whether it's discrete or a whole bunch of motions for partial summary judgment. So what's your thoughts, counsel for the state?
Your Honor, for the state, and I've done this in your department and others, but I think we brief them all on the same schedule, and then the parties meet and confer and send the court a joint letter on a proposed order to argue things, because sometimes, you know, depending on what the issues are raised in the different motions, you might want to argue them in a certain way, because a ruling on one might move others and those sorts of things. And so I know you've ordered my clients to do that in other cases, and so that would be my.
I've offered that opportunity for the parties in other cases.
Yes, you've suggested that, and we've taken your suggestion.
So is from the state's position, you're fine that the motion eliminate deadline has the same schedule as dispositive motion deadline. And the only thing that you all are going to do is closer to the time, you'll send me a joint letter in the order in which the parties want them heard. So you might want motions eliminate interspersed with some of your MSJs, et cetera. And it's going to depend on how many days they need to be over. Is that what you're saying?
For the state, that's correct, and I would include expert or Hallmark type motions in with motions eliminated, all be filed in the same schedule.
All I was saying from a practical purpose, since I have a variety of people who may not have appeared in this particular department before, that, and in the 8th Judicial District, that while some people might say that motions relating to experts come as motions for partial summary judgment, sometimes there are still motions eliminated, which is the reason I was giving an explanation on why the court was thinking it made sense to do them together, and you all get to pick the order they get heard. I'm generally fine with that as long as there's an agreement.
I think that our inclination is we would propose that all hallmark motions be filed at the same time with the summary judgment motions. But given the fact that there could be substantial narrowing regarding the issues of evidence that would arise in the motion in limine context, I think we would propose a later time frame for the motion in limine and not be joined with the dispositive motion and hallmark motion deadlines.
There is no hallmark motion deadline. Okay, all
Right,
summary
the
judgments.
dispositive motion deadline.
It's dispositive motion deadline, dispositive motion deadline. The only question becomes, I mean, if you do the 8 weeks before, what you're doing is you're not saving, which I think you think you're saving. Because all your motions are going to be due in the middle of your briefing of the dispositive motion. So any of the advantage that what I'm hearing you say is you might want to think that there's a decision on a summary judgment motion might determine whether or not you file a motion limine. But that can't happen with the schedule that you all just stated because, right, if you file them after, then that's not going to work because that's not 8 weeks before trial. We're under a general schedule. And given that you're probably doing more than quote, a general schedule case normally has, I'm gonna have to require that they're gonna have to be filed earlier, so you're really just having them in the middle of the briefing schedule, you don't seem to be getting the same thing, whereas if you file them at the same time as your dispositive motions, then you do have a little bit of flexibility on how those get heard between motions limine and motions for summary judgment, which many of you are familiar with in a variety of different cases, you all have done it that way, but.
And in those, so just so I understand, there'd be a time at the point that all these are filed in advance of the hearing where the parties would propose what order we would want.
I'm going to put a status check. I mean, you have more than one status check, right? But you're going to have a status check likely in November and likely in either November, early December, okay? Where given, no, it'll probably be after November 6th and before December 4th, you're likely to have a status check. I'm going to ask you, this is in no way committing myself, but if you historically, usually during that time period, the parties have asked the court, well, because now you know what motions you filed, right? Can we determine how we would like these to be heard? I'm generally amenable to that. I can't think of a reason I haven't been, but I can't say that somebody presents a situation that there's some reason for me not to do it that way, but normally I have because it makes sense for the parties because you want things heard usually in a certain way, and I'm generally fine with it. If the parties object or there's a conflict, then of course I have to resolve it. So to answer your question, yes, you all then usually send me a letter. We want document number blank, title blank, you know what I mean? This is the order we would suggest having it heard. And then if there's a conflict, people put a plaintiff would like X and defendant would like Y. And usually there's not a conflict because usually there's an agreement because, for example, take one of your expert motions, right? You might have expert blank cannot discuss X and the state may have expert blank can't discuss Y and it's an overlapping topic, right? So you usually want those heard together. Or maybe there's a motion and a counter motion on a particular sub issue, right? And so you want those heard together rather than one heard being one day and one the next day because they commonly come together. And that in no way allows people to file inappropriate counter motions, in no way says that there's OSTs or extends any deadlines, all that kind of good things. It's just really, it's for convenience of the party. I'm fine with it if there's a particular order, just if it makes sense.
Well, one of the concerns that I have as a practical one is in reference to just the number of briefs that might have to be filed on a single day. I think my proposal might be to set off by one day the motions in limine from the dispositive motion deadline so that there's just 2 different days where we're filing the briefs, and that hopefully won't have to affect by a great deal the timeframes that we're looking at hearing because it's only a day.
Well, then you chopped off one day from your reply because I'm going to need the replies on the same. We're not going to chop off a day at the end for the court to get the replies. I'm going to, okay, so you want
Parties
to.
can always file early.
Pardon?
Parties can always file their briefs before this deadline.
Well,
if
except
they
for,
can't get
let's
it
be
done.
clear. If you all were to file hypothetically 2 briefs a week for 6 weeks, you can appreciate the court might find that in the interest of judicial economy, I might be consolidating hearings, okay? Because you can appreciate 700-800 other cases whatever I have on my dock, you know what I mean? You're my most
Not
important case
suggesting
on this
difference.
particular moment, but you can appreciate every case is my most important case, and so I would not. Let's put it this way, no one has ever tried that. Okay. To do it that way, but you can appreciate from a hypothetical standpoint, the court's gonna have to evaluate when it gets briefs in, which is why I try and give you the opportunity to do your own deadlines right now, right? Now you can file them some earlier, right? But it's not consistently like if you were to file 10 briefs a day for like a week, you're likely to get those consolidated because court's gonna have to review them to see what makes sense. That's no way an advance opinion that I'm going to do it, because no one's ever tried it, so I don't know. But I can't imagine if something like that happened, I'm gonna need to look at those and say, look, there's a brief and another brief that look the same. There's no reason to hear one on one day and one on another day. But
Understood, and I wasn't
unless there's a
suggesting,
reason that it needs to be heard, you know what I mean?
yes, Your Honor, I wasn't suggesting that we'd have a serial hearing dates for various motions. I was just suggesting very practically, if there's, let's say 10 motion and limines on either side, that.
If there's only 10 motions eliminated, I will be doing a happy dance.
I don't anticipate that's the number by any stretch, but I just
You
anticipate
won't be
that'd be
seeing,
quite
you won't be
quite a lot
seeing
of
it, but,
filing
okay.
alongside dispositive motions and all the exhibits related to those.
And let's be clear, you won't be seeing said happy dance. Okay, but I'm just, okay, if you're only filing 10 motion, I'm anticipating that there is a larger number of motions in light of so far what's happened in this case and the multitude of issues. I would love if there's only 10 motions on each side.
I was not representing that we would be filing 10 motions. I
You want to
anticipated.
stipulate, 7.5
I'm not
oh is fully
stipulating.
available.
Read the cap meta.
I am frankly just saying that at that completely unrealistic number, that would be 20 motions that would be filed alongside whatever summary judgment motions.
The court is, if the parties want to do it by a day or two, that's fine, but I am gonna have to chop off that day or two with regards to the replies. If you're gonna want to have the opportunity to provide an order of how you want to have motions done, right? Because de facto, you're chopping off time to get prepared,
Understood, Your
you
Honor.
know,
Understood.
so.
Your Honor, the state would prefer to just have this scheduled November 6th, December 4th, and January 8th for everything.
Is
And
there
if
any
someone
strong
wants to
objection?
file early because they don't have enough staff to get everything together and filed on the deadline, that's fine.
I'm not making any aspersions about the staff that is going to be filing. I mean, they have worked very hard in this case over a long period of
Do you
time.
want to check with your local council?
He's got 2 of those.
It's physically impossible to file like 100 things in one day. It's physically impossible. So, it's.
Oh,
His point's
realist,
well
oh.
taken.
State, wouldn't necessarily agree with that. I think I had 87 filings the other day, on Monday, that came into this by noon or something, was whatever. Okay, so
Yeah,
folks, what do you want? We need to move on. This is of all the,
yes,
I'm
Your
more than glad
Honor.
to handle your issues, but this seems like I
We're-
need to
we're
put
down at
deadlines
the
put
beats
in
now.
order.
They've got
We're
2
happy to
years to
proceed.
prepare
We're
for
happy
these
to proceed.
filings. Yeah.
Which is it?
We're fine to proceed in the fashion with the single date.
Okay, for motions, eliminate and dispositive motions, okay? And there shouldn't be any other pretrial motion, so please don't, I'm not in any way saying that anybody would call something different and think they have a different deadline. But the court looks at substance, so I don't look at labels. So I've had people try and file other motions with different titles and say they weren't covered under just dispositive motions or motions eliminated, so they could file them a lot closer to trial. So now I have to make that statement, not in any way implying that anybody in this courtroom would do that.
Understood, Your Honor. The deadlines are the deadlines for all the motions before.
Yeah, okay, shall we move on? So let's see which deadline we have not yet dealt with that we need to address for you all. Okay, we have taken care of close of discovery, we've taken care of motions to amend, we've taken care of your experts, we've taken care of your motions for summary judgment and your motions eliminated. We've given you a trial paren S end of paren date. We have your pretrial memo will be triggered by that. Now, are you asking me for that? I was putting you on a stack. Does it make any reason? Is anybody requesting that I turn that into a firm on the first day of the stack?
I don't, Your Honor, no, the state is not requesting that at this time.
Okay, it's just because if you all need for planning purposes, because of the anticipated length of the trial, paren S and a paren.
I just know how that might affect your ability to manage your docket with other things, and we're so far away from that date, I would hate to tie it up
Okay.
quite yet.
Not at this time, Your Honor, I think is the way to describe it.
Okay, then we don't have to go to that. We've given you your estimated time. I'm not gonna give you your pretrial conference and your calendar call date. Read the trial order, right? We'll figure that out. Those might be okay. We might need to. We need to likely move it. I'm not likely to do a calendar call date the week before because of the extent of things that you probably need to address. I don't need to go over exhibits. You all know what you need to go over exhibits, although I do need to go over exhibits only in the context of yesterday's filing at 5:35 PM on the proposed order regarding discovery of electronically stored information and hard copy documents. Printed document applies to all cases that was submitted to the court. Is there anything that was stated today? I've done a quick perusal of said proposed order, all 44 pages of it, 45 pages, excuse me, of it. But there was like one sentence in here that maybe a little inconsistent with what you all said today. Does anyone want to look over your proposed to see if anything that was stated today needs to modify anything in your ESI?
Not for better, Your Honor.
Okay.
Your Honor, for the state, I think we're okay, but the state would be willing to meet and confer with Meta for another day and.
Page
resubmit it.
32, your confidentiality aspects might be impacted by what my inclination and depending what the ruling is with regards to the experts. Paragraph 10, confidentiality designation on page 32. That was one of the two things. And what was my other note? Oh, 5.9 on page 11, phase production. I didn't know if you all needed to look at those two provisions. Y'all may want to take another look at those just to see if that's everybody's intention. You don't have to look at it right now. Just do me a favor, by Friday, send me a joint letter to say, Your Honor, what we submitted on the 21st is what we'd like the court to review, or Your Honor, we'd ask you to withdraw what was submitted on the 21st. Please review this new one and please see pages blank and blank where there's changes. So I'm not going back through 45 pages to try and figure out what those changes are. Does that work for everybody?
It does, Your Honor.
Yeah, yes, Your Honor, I think that makes sense after we
Okay.
resolve the motion for protective order and take a fresh look at that.
Okay, and I'm not limiting you to those two provisions. Those are the ones I saw just with regards to today. So, okay. Protective order. I gave you my inclination. So, oh, wait, hold on a second. Oh, I need status check dates. Yes. Thank you, my wonderful JEA. Status check dates. Do you just want us to fill some in early? Makes sense right after initial expert disclosures is normally what I would do it in this kind of case. I mean, I'm gonna do another one before November because I already currently have one for this year. Right, September 18th, I believe is what I put on your one with the CMOs, and I have another one, so. Do y'all want to propose some status check dates, or do you want me to do this? I mean. We've got a couple of ways of doing it. Sometimes what we've done is we've done a series of status check dates as we've done in some other cases, right? And then if parties don't think that there's something that currently needs to be pending, you send me a quick little status report that says, Your Honor, we don't need anything for this, status report. We request you vacate it. I evaluate that. If it makes sense, I vacate it. If I still think there's something needs to be done, it needs to be done. If you want to do that, we can do that. Might be more efficient for you all to talk among yourselves and propose a series of status check dates for the court to do it in that method. And then that same by Friday, let me know. If not, I can take the time now and we can work out a whole bunch of status check dates. What do y'all want to do?
Your Honor, for the state, I think it makes sense for the parties to meet and confer on this. We're considering the special master's request for regularly set hearings. I think there's less of a need for periodic status checks with the district court because we'll be doing a lot of discovery there. But I think it makes what my request would be that we meet and confer and communicate with the court our preference. And if we can't agree on something, we'll let the court know that.
Meta joins in that.
Give you a heads up, if you propose something in the court that's more than every 90 days, I'm likely to put you around about every 90 days, just to let you know.
Okay.
Because can't, with a case this size, too many things pop up, and realistic, even in opioid and some other ones where there was lots and lots of special master hearings, we still did these because there's just things that pop up, okay? Or at least I get the status report that says that there's nothing needed and I can evaluate it, okay? So there's a heads up. If you want something more than that, I'm more than glad I'm here, more than glad to accommodate. Okay,
Thank you.
does that now take care of everything with regards to our Rule 16? Because my wonderful JA might need to get back to everything else that she needs to take care of.
Yes, Your Honor.
Councilman Meta, anything else?
Your Honor.
Okay, thank you. Thank you, Tracy. Okay, getting to your motion. It's Meta's motion, so I guess my first question is, did you all come to some resolution or am I resolving it?
We did not come to some resolution on the protective.
Okay, then go ahead, Council for Meta, your position.
Yes, Your Honor.
Go ahead.
Thank you, Your Honor. I will be brief and to the point with regard to my comments on the protective order here. Given the court's mention of her inclination, I will make a couple of quick points based on that. First, we would certainly agree with the court's description of her inclination to allow for some version of this type of provision. And the one thing I wanted to clarify about the provision that we put forward to be able to enforce this idea that there needs to be some step that happens with regards to the highly confidential material that is being disclosed in discovery is that the provision that we've proposed is actually even-handed in the sense that both Meta and the state have the same obligation under the provision. Whether either party wants to allow any expert to be able to see highly confidential information, both Meta and the state have to provide the other side simply the name of that person and their CV or resume or their website as a means for identification for the other side. And so there's no unfairness that is inherent in this type of provision. And recognizing that it's Meta's highly confidential information, but we've put forward and have been willing to take on this obligation to ensure that there is an even-handedness and a fairness to what we've proposed as part of the protective order. It has been entered in nearly every jurisdiction. In other cases we have cited in our brief, it has been entered, and the only concern that the state raised in response on the substance of this provision is merely the fact that there would be some kind of earlier disclosure of a particular expert before the deadline. And in each one of those other cases, and we cited to the Utah case that's been going forward, the DC case and the provisions that's gone forward, as well as other cases like the Google case, where a California court evaluated the same argument. The response from the courts have been consistent, saying that yes, merely this disclosure just identifies public information about the expert and doesn't identify what a disclosure is meant to identify, which is the facts and the opinions that they're going to offer in the case, which is distinct from just merely identifying who the person is. There's no prejudice that really comes from that. There's no litigation advantage that comes merely from knowing the name and the CV or resume of an individual. And as part of our back and forth, we proposed, and I think the state recognizes, that this would merely only address new experts that hadn't been disclosed previously in the litigation, and the state wasn't willing to agree to that. So I think overall, this type of provision is very important because of the highly confidential information that is being exchanged in this litigation, and executing on it in an even-handed way is done by what we proposed, because both sides have to abide by the same rules that we're putting forward.
Okay, so I do have one question. So just so I have a clarity, so walk through and remember, this is being recorded pursuant to a media request, so I'm not in any way asking for any true highly confidential information to be provided as an example. So, but just example X, right? So whichever party retains John Doe expert, they're just going to be providing John Doe's name, John Doe's CV, and then is it the burden of the party that wants to potentially object to, say, highly confidential documents, base stamp number blank to blank, should not be provided to John Doe expert, and then the special master makes that determination subject to report and recommendations to this court. Just walk me through what you're seeing potentially as a step, because my one concern, it was really part of the proportionality, you know what I mean, and how much cost and expense, I mean, and time that was gonna be this. I mean, I see it can be very effective depending on how it does. Can you walk me through some of the mechanics?
Happy to walk you through the mechanics of how this works, and I'll clarify just right up front. There is no process by which we're identifying particular base numbers of highly confidential documents. So that step won't be happening. Here's how it will occur. Either side engages with a particular expert witness, John Doe expert witness. And at that time, they can provide any of the confidential documents, which is most of the productions that we have made in this litigation. And only does we make our productions, they have date stamps on them, we identify them by confidential, highly confidential, as it's reflected in the protective order. Only if a party wants to provide John Doe the highly confidential set of documents, at that time, no matter how many or no matter what highly confidential document it is, at that time, all they have to do is send an email and say to Meta, it's John Doe expert witness, or Meta sends it to the state. John Doe expert witness, we plan to disclose highly confidential information to. Here is his CV, or here is his website. And then there is a 7-day period by which the other side can say, we object. And if the side that's objecting says we don't want John Doe to see the highly confidential information, then the burden is on the party that's objecting to come to court. And in the first instance, procedurally, based on how we've set up the special master, would procedurally probably be in front of the special master. And that person, that side would have the obligation to say, well, John Doe shouldn't be able to see highly confidential documents, any highly confidential documents, because he is currently consulting for TikTok, for Snap, for Google, for a competitor. And the highly confidential documents in this in this litigation represent a risk of harm to the business, such that he should not be able to see that information.
Okay, so that leads to two questions. Is there a meet and confer similar to the Nevada requirement under the EDCR for a motion to eliminate? Meaning, is there any meet and confer? Because conceptually, right, some of those highly confidential documents, I really don't want to pick any potential type of expert because I don't want to give any indications one way or another, but I could see that certain experts might have areas of expertise that might not really overlap. And how would the overlap with the issues that are in the highly confidentials, right? And once again, we don't know how many highly confidentials there's going to be, correct? It could be 2, or it could be 10,000 or something even more. Okay, kind of with your 10 motions eliminated that I'm only going to see, maybe it's only 2 documents.
Yeah.
I understand you did not commit to that. I'm kidding around in that regard, but okay, it's probably more likely in a larger number than 2 pages. So how would the deciding judge, special master, whomever, be able to evaluate what you're requesting if there's not a designation of which documents are the issue of concern?
That's fair. So the process would continue. I should have completed the entire process. Within 7 days of delivering the request, there's an obligation to object, and this is under Section 36 of the proposed protective order, which is attached to our motion for the protective order as exhibit number 1.
Right, okay.
So within 7 days, the party has to object. And if we object, then there has to be details that are set forth. And then after that, there's an obligation for the parties to meet and confer through direct voice-to-voice dialogue to try to resolve the matter by agreement. And only if no agreement is reached, then the producing party may file a motion for a protective order. that would preclude the expert from receiving the highly confidential within 14 days of the written objection. So.
Right, I read this, but take my example, if it's 10,000 documents or 1,000 documents, right? I mean, 1,000 pages. How would put yourself in the shoes of the person who's making the decision, right? You're trying to say you want a protective order. Normally you get a protective order, right? Sometimes you do in-camera review. Actually did in-camera review about 153 different documents with, you know what I mean, that weren't just single pages. I'm just saying, you know, in order to evaluate whether or not they should have the protection. Judges want to make well-reasoned decisions, special masters who are former judges want to make well-reasoned decisions, right? So how would that work out with, what would it be brought up? Just the concept of, look, this person works for a competitor, so de facto, they can't see something that's highly confidential, or is there going to be something more narrowly tailored that says, well, because this expert's in field blank, you mentioned medical causation earlier, so I'm only going to use that example because you've already brought up, right? That is it an argument that because of the nature of their scope of their expertise, they shouldn't get it because it doesn't really cover within their scope of their expertise? I mean, I'm seeing issues conceptually reads really well, but I was trying to see how it actually would really work out.
I think the nature of our concern with them being a part of a competitor or affiliated with a competitor or having some relationship with a competitor such that it would raise the concerns triggers the entire group of highly confidential information, because the nature of the highly confidential information is information or protected material, the disclosure of which to another party or non-party would create a substantial risk of serious harm. And so the nature of their relationship with the competitor in the business would implicate the highly confidential information in the production. Now, to the extent that the special master or this court would want examples of materials that are of particular concern with respect to a particular expert and their relationship, that could be a part of the motion for protective order briefing that would take place afterwards.
Cutting to the chase, that Supreme Court Rule 3 requires the court to do a specific evaluation, right? No district court judge can, nor can a special master, disregard a Supreme Court rule, right? I think everyone agrees with that concept, right?
Yes, Your Honor.
So that means Supreme Court Rule 3 says that this evaluation needs to take place, which is why I'm asking the practical question of how in Nevada, consistent with the parameters of Supreme Court Rule 3, can this work out in practice? I fully understand all your hypotheticals and the concept, right? You don't want someone to have 1 page or 1,500 pages of something that may be, but I have to look at it in the context of, it's similar to sealing and redacting. I appreciate Supreme Court Rule 3 goes to sealing and redacting specifically, but you're in essence having those be sealed because you're not having them come in for certain purposes. And I'm not sure if you're saying that means they don't come in for any purpose in the case, because once they're in the trial, i.e. see a very recent Supreme Court case, which said, okay, it was the Humana case. I believe it was Humana. There's a June, whatever. I actually brought a copy anyway. A very recent case that basically said, if if it comes in at trial, right, no objection, then good luck saying it's confidential. Was it Tormero or was it Humana? Anyway, it really doesn't matter. See. Second, but I really was trying to put your request, which seems very reasonable, into that concern of how the decision maker is able to do, well, in this case, it's her and her job. But for him, I don't know if somebody's gonna sit for me, right? So,
Well,
and do that evaluation. And maybe you're gonna tell me Supreme Court Rule 3 doesn't apply at all because it says sealing and redacting. However, conceptually, that is what you're asking. You're asking for the non-disclosure of something to be in litigation that has been produced in litigation.
I think we're asking for something a little bit different
Okay,
than
go ahead.
sealing and redacting. And the reason I say that is we are asking for not the public. It's not a question about public access or public disclosure, but in this instance, it's really just a single person, a person that's serving as an expert witness in the litigation, whether they're allowed to have access to information that could be of business harm in the way that's described to the company. And so I think the evaluation of our protective order briefing will be focused on what the nature of that person's relationship is to the competitors. But to your point, to the extent that I don't think Meta would object if the process was revised for the party that wants to show the highly confidential information to specify what that highly confidential information is that they want to show. And for, as a part of the protective order briefing that happens afterwards, the burden is on the party that wants to protect the information to say, okay, well, that highly confidential information should not be shown for this expert, and here's why. And so if the hesitation is identification of the highly confidential information, I don't think that we'd have a problem with creating a process by which that highly confidential information is shown. What we would not want would be for the party to be able to just show whatever information they wanted at any time without some kind of provision that provides such protection. The process of the briefing and what details need to be included in that briefing to meet the burden that we'd have under the rule, we can put forward. But I would say that we should not have the same burden as sealing and unsealing, because for sealing, what we're talking about is filing something on the docket or having something in open court where the entire public would be able to see it. Whereas in this instance, it's really just an expert witness that's involved in the litigation.
But counsel, I'm hearing you say that, but by you marking it confidential, or in this case, highly confidential, de facto, the public isn't going to see it because, by the way, it was the United Healthcare versus Fremont Emergency Services. It came out June of 2025. I knew it was June 2025. Huh?
I've heard of that.
You might have, yeah. Sorry. So if you are de facto saying the entire public or not, right? Because that's the whole reason. That's how you're calling it highly confidential, because if it was publicly available, it wouldn't be highly confidential.
Yes, Your Honor, if it's not going to be publicly available, but none of the information that's marked as confidential or highly confidential is just in any litigation is just automatically publicly available. As soon as one of the litigants wants to use it in the public sphere, then we have the fight as to whether it should be allowed or should not be allowed. There's no fight that happens about the whole expanse of confidential documents in big litigations just because you've marked it as confidential. There's no further justification that needs to be required just because you've marked it as confidential or highly confidential in the course of producing the documents. But it becomes an issue if you want to use it in trial or in court. And in this instance, all we're doing is not evaluating whether it should or should not be allowed to be seen with the public. We're evaluating whether this person is a competitor so that the protective order provision that protects this information against competitors should be invoked. It's a narrower and I think much different evaluation compared to the public access to a particular document.
But public isn't, okay. If I'm hearing what you're saying, but walk it through, right? For sealing and redacting, okay? You want to use a particular secret sauce, okay? Let's go secret sauce. The secret sauce you want to say because you want to say competitor A took the secret sauce, right? So you have to show that it is secret sauce, that it's not just mayonnaise and ketchup, okay? Right, whatever the secret sauce, I don't, but okay. So, so you may want to put in that, look, it's our secret sauce because we do it this unique way. It's parts X, you know what I mean?
Right.
Adding this part Y, we process it this way, blah, 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 right? And you want that sealed because you want to show, in order to show it meets whatever standard you're trying to meet, right? To preclude somebody from getting it. Now, whether that goes to an expert showing it, you know what I mean, to try and do damages, you're gonna have that same sealing redacting because you don't want the secret sauce recipe out there, right? And if they're trying to say the damages of the secret sauce getting out there, they don't know what the secret sauce is. Or you're using it in any kind of motion practice, right? To preclude something. That's all sealing redacting, both for the public, and in your case, you're adding in experts, which normally experts have access to documents that otherwise might not be filed for the public eyes. So I'm not seeing how it's narrower, I'm seeing how it's broader, because you're not only saying the public's not gonna see it, because if the public could see the document, it's not highly confidential.
Right,
I mean, by definition, right? So I'm seeing you're adding somebody who normally has the opportunity to see documents, right? In the ordinary course, attorney's eyes only with experts, and now you're saying we need to do this. So it does circle back to the concept of if somebody is, you can't just stamp it highly confidential and say, because in that case, people would stamp everything highly confidential,
Right.
right? Okay, so there's got to be some mechanism that the documents at issue truly meet the definition of highly confidential, which gets you over partial burden of if you want to possibly file it in something, right, for sealing and redacting, but then also it meets this extra special aspect with regards to an expert for this additional concern. It's, not only secret sauce, but the guy works for the competitor who, might be trying to get your secret sauce, okay? And I'm not in any way minimizing calling this secret sauce. I'm just trying to use something that's so totally different than what you have, okay? So it does circle back to how a jurist or a special master is able to evaluate the need to preclude the expert from getting access to, because you're not saying a document, you're saying everything marked highly confidential.
That's correct. That's correct. And
So what would you put in, I'm hypothetically doing a pleading, right? Your pleading is like, because we've stamped it highly confidential means that the expert can't get it. Judge,
And-
that's all you're getting? I
and the
mean,
reason for that is because the evaluation would really be of the relationship between this expert and a particular company or work that they're currently doing. That would mean that they would be able to use that information for purposes that it shouldn't be able to be used for. I think you're right in the sense that, but in this world, the parties have agreed that largely to a protective order occurring. And so that agreement reflects, well, for people outside in the public, they shouldn't see a certain group of information, and there are only people that should be.
I'm stopping you for a second, because remember, just because the parties agree, the Nevada Supreme Court has said the court still has to do an independent determination. Just because you submit a proposed protective order does not mean de facto it's signed. It's got to meet all the belts and suspenders for different aspects for a court to make its own independent determination if it can be signed.
That's
right?
correct.
Okay,
That's
right.
correct. Within the world of the people that would have access to the documents, you are right. What we are doing is doing one step further, which is there's a group of people that shouldn't have access to a certain band of documents, the highly confidential documents. And we say that Meta, the one that produced the document, has the obligation to be able to show, whenever asked by the special master, that there's a reason for that. This person has a relationship with another company such that it's justified. Now, if the court's question ultimately is, I want to be able to evaluate the highly confidential information itself and the relationship of that highly confidential information to the company. I mean, as a part of our briefing process to meet our burden to address it, I think we would be in a position to be able to speak to what highly confidential information is being shared if the state in the scenario we're talking about says, this is the highly confidential information we plan on sharing, and we can meet that in the proceedings where we have the burden of showing that this expert shouldn't have access to the information.
Okay. Do you have your proposed protective order in front of you?
I do.
Okay, page 12, paragraph 32, starting around line 10. And I'm not going to quote from it right now because you've not yet submitted it as a public document, so I'm just going to reference it, okay? Do you see that sentence about nothing shall be construed to limit or restrict the use of?
Yes.
And then you see your paragraph 36 on page 13. So how is one reading those two consistently? If nothing is supposed to limit it, but yet it's limited. And
What I'd say is the reference in the broad discussion in paragraph 32,
which says nothing contained, that's the whole order.
right? there's it's fair to say there's a more specific exemption, almost example of what Meta is willing to agree to make sure that this is even handed in saying, okay, we will do the same disclosure, but I don't think that it means that I don't think that there's a tension between the two provisions with Meta's agreement that they will also be subject to the process that's laid out here.
Okay, maybe my question wasn't clear enough. When I was reading through this, okay, and I read paragraph 32. Generally, the language "nothing contained herein" means regardless of whatever else is in the document, right? You still can do X. Then I read paragraph 36, which seemed to make some specific requirements for the very thing that seemed inconsistent with the "nothing contained herein."
I see.
So that's where this court was. That's a separate question than kind of the route I was going on. I was really kind of going to a different area because I'm going to circle back, because once again, I'm looking at the eyes of if I'm asked through a report and recommendation, or the special master's asked directly, and that's, I got to clarify with the state that they're in the same agreement that goes to special master first, and then to me as a report and rec. But under that scenario, how does one reconcile those to say whether or not all these documents, which are quote highly confidential, either apply to the "nothing contained therein" that they can use it, or the expert provision? It's going to my general concept of how does the trier of fact and or the special master evaluate any concerns that come up. So you understand I'm making a distinction from the concept and the idea. I can see and I agree with. I do need to make sure that we don't, I don't sign something that is internally inconsistent and is going to raise more issues for trying to get a resolution. And
Well,
if you need a minute to think about it, I can ask the state and let them go and you get final word anyway.
I think my headline though response is the meaning of this provision, the purpose of this provision is to recognize that the party designating the materials is asserting a certain level of protection over the materials because of the reasons that they've put forward. In whether it's confidential or highly confidential, it is their information. It is ultimately the party's information that's being put forward. So whether that's
And how is it equal to your statement that it's equally for the state and Meta with regards to highly confidential? That's, you can understand that's exactly where I was going, right?
Right. And I
You're a
think
smart person, you knew I was going there, so.
I think it is Meta's information and
So Meta can use it, or Meta has to follow the
such that-
same protocol as the state with regards to an expert?
What Meta has decided to agree to as a means to ensure that this would be provided as evening handed. This was not, I mean, this has, because this issue has come up on several occasions, well, we've found a middle ground to be able to reach an agreement that both sides will have set obligation to ensure that that there's fairness here. I think that it is true that it's Meta's information and Meta should be able to do essentially what it wants with this information, but Meta has chosen to agree to a certain restriction in by stating that if they're going to share their information, our information, with a particular expert witness, they will provide said notice and the state would have an opportunity to challenge that.
Are you saying paragraph 32 says that?
I'm saying that the more specific procedure in paragraph 36 lays out what Meta has agreed to with respect to its information and expert witnesses particularly.
Thank you so much, appreciate it.